Bonjour. Bonjour. Bonjour.
Bonjour.
Bonjour, David. Bonjour.
Bonjour équipe E, bonjour équipe H. Premièrement, je vous demanderai de vous identifier équipe E. On est la partie de l'organisation. Est-ce que je lis les consignes en anglais? Yes? Hello and welcome to the presentation of the labor arbitration case. I will be reading the instructions for the presentation and then let the judge introduce themselves. Each team will have 12 minutes to present their arguments.
Okay.
A period of 5 minutes is allocated to prepare a counter-argument based on the presentation of the opposition team and the new argument. You will then have 5 minutes to present your counter-argument and conclude your presentation. The order of the teams always remains the same for both parts of the case, and it's the team with the burden of the proof that will start. During the presentation, each participant will have to speak. The minimum presentation for time for the first part of the presentation is 8 minutes and 3 minutes for the second part. Non-compliance with the presentation time will be penalized up to a maximum of 1 point every 30 seconds. For the initial 12-minute pitch, I will show you the remaining time using cards when you will have 5 minutes, 2 minutes, 30 seconds left. And I will count the last 10 seconds on my finger. For the preparation period of 5 minutes and for the presentation of your counter-argumentation and conclusion of 5 minutes, I will show you the remaining time with the help of the card and when you will have 2 minutes and 30 seconds left. If anyone on the team continues to speak after the end of the count, point will be deducted. And I will now let the judges introduce themselves and you may begin. Voulez-vous les consignes en français?
Vous allez vous présenter.
Diane Gagné, professeure à l'Université du Québec à Montréal.
Oui, bonjour, Kathleen Grouillard, avocate pour la partie patronale depuis maintenant 17 ans, 18 ans.
Pierre Saint-Arnaud. I am an attorney and arbitrator in labor law since 12 years.
Claude Rioux, I was for 30 years a union representative for the pulp and paper workers. And right now I'm doing training for the International Labour Office in Geneva.
Is it possible to have an example of showing the time just to be sure we see it perfect?
Before beginning, I have to read this statement that we are ready to hear your arguments, and I'm asking to the team having the burden of proof to begin with.
An employer must provide a safe working environment for its employees. They must also make sure to prevent any possible work-related accidents that can happen on its site. This in all is important for all employees. Good afternoon, everyone. Hi, opposing counsel and judges or arbitrators. My name is Elizabeth, and these are my colleagues, Fatima and Jan. Today, we are representing the side of the organization. The situation as we view it today is that Ms. Gagnon, who will now refer to be as the plaintiff, was rejected from her forklift position that she applied for in December 2017, after working with our organization for 12 years. The plaintiff does have the highest seniority possible for all candidates. However, the employees rejected her application due to her handicap, which is deafness. Today, we will go over our main issues. First being A, is the plaintiff suitable for the position that involves high risk given the auditory requirements? B, was the plaintiff a victim of psychological harassment? And C, did the employee demonstrate discrimination with their promotional process? We will refute these arguments. So A, the employee should not be given this position due to the clashing nature of the position and her disability, therefore putting at her risk and her safety to herself and the rest of the employees. B, given the interaction between the employee and the plaintiff in regards to the letter, there is no evidence for psychological harassment. There was significant amount of time taken into consideration with this analysis, and the way that she was treated after the promotion did not change. And C, this does not constitute as discrimination, the fact that she has an auditory disability, because this is to be considered as a bona fide occupational requirement that is required for the job. As considered by the Canadian Human Rights Commission, this situation qualifies as a bona fide occupational requirement because it was made honestly, in good faith, and with sincere belief that it is made for the best interest, the effectiveness, the safety, and the productivity of the organization, as well as it's objectively reasonable because it must be a sensible connection between the ability of the job and the employee to do this job. As for our grievance, the company would like for the plaintiff to remain in her current position while assisting the health and safety teams as well as the warehouse supervisor and develop provisions and accommodations for her disabilities. And therefore, once these new accommodations have been tested and implemented, the company would there like to extend the role of forklift driver to her, granted that she can be able to pass the 10-day training. The factors that we'd like to consider today are timeline, employee performance, company policy, proportionality, extenuating circumstances, and precedents. I will now go over the timeline. So in December 2017, the plaintiff applied for the forklift driver position, and the Director of Human Resources met twice with the Director of Health and Safety as well as the head of the warehouse. Together, they analyzed the case and made the consensus that the employee should not be extended the position. On December 22nd, 2017, the Director of Human Resources informed all parties of the decision and then extended the rejection letter to the plaintiff. In January 2018, the union filed a grievance on behalf of Annette Gagnon, and in October 2018, the case was presented to the arbitrator. What we'd like to really reassess to you is that the decision of this position and not granting this promotion was taken into a lot of consideration, and this decision was not made lightly. I'd now like to pass it on to my colleague Jan, who will go over employee performance and the company's policies.
Thank you. In terms of employee performance, it is no secret that Mademoiselle Annette Gagnon is impeccable. Her record is clean. She has showed up every day for the past 12 years, loving her job. She is a great employee and an even greater asset to the company. That being said, her abilities to work her day laboring job might not necessarily translate to her ability to operate a forklift. The plaintiff's track record in her current position is not representative of how she would perform as a forklift operator. In terms of company policies, it's important to keep in mind that there is a definitive zero tolerance for discrimination across the company. The company prides itself in its ability to have a diverse and open workforce. That being said, from the collective arguments, section 10.17, the employers allow themselves to defer from the seniority in case that an employee would not necessarily be able to operate the tasks of whichever position. As it stands right now, Mademoiselle Annette Gagnon is an incredible employee, and the employer is very happy to have her in the company. That being said, it is just not realistic for the time being for her to operate forklifts, considering that a forklift driver needs to have very strong coordination and communication abilities with every single other person, whether they're on the floor or moving boxes. There needs to be a constant source of communication in order to ensure the employee's safety. And that is the #1 concern for the employer. Now we'll be moving on to Fatima for the extenuating circumstances and the proportionality.
So the 2 points I will be addressing are proportionality and extenuating circumstances. Proportionality, the question in hand is that does this claim match the situation and its circumstances? The claim brought forth by opposing counsel was that there is psychological harassment in play from the rejection that was offered to the employee. The rejection was given in the form of a clear, concise, discreet, and politely worded letter, and there was no room for misinterpretation. It was highlighted that it is not her performance that is in question, but rather the job requirements of the forklift position. In the end, the plaintiff was able to continue the role that she has been excelling in and has been an asset in for the last 12 years. Her treatment wasn't altered following the declination of a promotion, and nor will it be altered moving forward in her role in the company. For extenuating circumstances, we do acknowledge that she is the most senior individual within the company at the moment, and that puts her next in line for the forklift position. However, she was declined the position not because of her seniority, but because of the role of what the role requires. She was declined the promotion because without measures in place and provisions provided by the company, it is simply unsafe for both her and for all the other employees in the company for her to be operating a forklift. Ultimately, the circumstances of the company right now prevent them from being able to offer the plaintiff the position in operating a forklift. Being able to accommodate the plaintiff is a priority in the future, and provisions are intended to be put in place. However, currently with a 10-day restriction from the collective agreement, it is simply impossible to promote her into the position at the moment. Now I'll pass it back to Elizabeth, who will address the precedence that shows that not promoting the plaintiff is an implementation of a bona fide occupational requirement and is not a form of discrimination.
Thank you, Fatima. So the precedents that we will highlight today are 2 specific cases. Our first case is Binder v. CN in 1985, which looked at bona fide occupational requirements. In this case, CN had imposed a workplace rule that required its employees to wear hard hats for specific positions. In this, one of their employees, Binder, who is a Sikh man, was wearing a turban, refused to wear the hard hat because that implied going against his religious beliefs, as he was not able to wear a hard hat on top of his turban. The CN then tried to move his position to something that would not require him to wear a hard hat. However, the plaintiff in this case decided that he would not accept that position. Therefore, CN fired him due to the fact that he did not follow the workplace rules. The plaintiff in this case tried to argue discrimination. However, the Court of Appeals justified this firing by stating that the wearing of the hard hat was a bona fide occupational requirement of the job. And therefore, this does not constitute as discrimination because the wearing of the hard hat was required in order for him to go about the safety and the duty of his position. Secondly, what is important about this case that we take away is the parallel between CN and what is happening with our plaintiff today. Her inability to hear is a bona fide occupational requirement right now, considering that there are no other accommodations in the work that she is doing. Secondly, there is a via rail case against the Conseil des Canadiens avec défiance, basically saying that Via Rail upgraded its fleet in 2007 and did not provide any accommodations to people in wheelchairs. They tried to argue that they had undue hardship because they have to re-update all of their fleet to make these particular accommodations. They ended up losing the case because Via Rail is a billion-dollar company that is necessary to provide all services to all Canadians. In this, we'd like to see the parallels due to the fact that this undue hardship, so being able to then invest and put in these potential accommodations due to the size of the organization, the operation, and the timeline are insufficient. Due to the fact that this workplace cannot be updated within the 10 days that the plaintiff would have to finish her training in, would not be sufficient. We thank you for your time of listening to us, and like we said again, we believe that the company made this decision within good faith and only to make sure that the plaintiff is safe as possible in her role. Thank you.
Side employer began their presentation talking about how it's important to create a safe environment. Side union believes that a safe environment is also an environment free of harassment and discrimination. Dear employer, distinguished audience, and esteemed panel, we are representative of the union. My name is David, this is Nicholas, and this is Vincent, and we're here today to talk about the case of Annette Gagnon. We're here to resolve some failure that the employer perhaps might have missed in their analysis, and we just want to bring them forward in our case. There are 7 things that we would like to highlight. First of all, we would like to be able to prove our point by the failure that the employer had to understand the collective agreement provisions and the law. The failure to accommodate, the failure to properly evaluate the workplace and the work to be done, the failure to understand provisions in the collective agreement, the failure to understand injuries caused by forklift drivers, the failure to acquire information on deaf driving, as well as the failure to understand previous judgments in similar scenarios. So, if we start by understanding the collective agreement, in Article 2.1, there's a standard provision for an anti-discrimination clause. This is something you would expect from any type of collective agreement, and this is something that the employer was generally able to respect. However, some points that were brought forward underline the fact that you are required to hear to be able to drive. And side union believes that this is not true. In fact, moreover, my colleagues will point out later that driving does not require actually hearing, and our plaintiff, Mrs. Gagnon, has a very good driving record at the moment. Second point under the understanding the agreement, it's important to highlight that 10.1 defines the seniority that should be the main factor in attributing promotion. We understand that there's a clause talking about people that are unfit for the job. However, we believe that in the event that this would not be a provision, that it should be proven why they shouldn't be able to take on the role. And my colleague will also explain to you why this was not respected. Finally, the Quebec Labor Code, Article 81.18, highlights psychological harassment. One key thing that I would like to bring forward is vicious situations. So we believe, as we know, harassment, psychological harassment is not only a repeated thing. It can be based only on one event. And this is really the element that we see here. We believe that Mrs. Gagnon was actually discriminated against her disability. Second to our point that we would like to bring forward for the employer is the failure to actually evaluate the work to be done and the workplace. And this is divided into 3 arguments. First of all, no test was actually done before giving a judgment to say that she was unfit. We understand that now the employer is offering a 10-day trial period. However, Mrs. Gagnon was still discriminated against her disability. The second point I would like to bring forward is that saying that she could injure someone by being a driver does not actually solve the problem. It just highlights that there are some situations in the workplace that can actually cause harm. And we believe inside union that this is comparing the situation we have here to not hiring somebody in a wheelchair because they could not get out of a building if there was a fire. So we really believe that this is not comparing apples to apples. We're not looking at if a deaf person can actually drive a forklift. We're just looking at if somebody deaf can hear. And that's really not the case in this situation. The third point we would like to bring forward is that saying that she should not hear is actually a cause and effect scenario. So the fact that she would hurt someone while driving, if that would ever happen, is actually just a cause of another situation. Maybe the person in the back was not looking around. So there are other situations where we could prove the environment to be fit for somebody with a hearing problem.
The arbitrale also failed to accommodate. The employer failed to meet the minimum requirement to try to accommodate Mrs. Gagnon. They discriminated against her by rejecting her candidacy without doing a proper search to accommodate her in her role. One way to accommodate her would be to retrofit all the lifts with backlights that would actually flash and make every lift much more visible to everyone around her. There is also, Mrs. Gagnon also stated that the employer has never implemented special security measures to protect anyone, her included. They didn't do anything, and they don't seem to want to do anything. And they never addressed her about her handicap and how they could make the workplace better for her. They only take it as granted and thought that she would be okay to work in that environment. It also provides the perspective that the employer never did the due diligence to make sure that she was safe in the environment in which she was working. We have to know that this employee worked 12 years at the same place, and that made working around forklift, the only difference is she was on foot and she has a spotless record. We can ask ourselves, is it much of a difference if she's on forklift?
Members of the board. Mrs. Gagnon has been working for 12 years at the company. She has, as we said, clean record, and she has been driving for many years. And she has been also cycling for many years. Where I'm going with that point, it's not to compare it to forklift, because forklift is something that is quite different. It's something we need to understand with that is that the ability to use a forklift is not with ear, with the eyes. And something we can compare it to is someone that is working in the construction plant or is working on the airplane site that need to use air protection because the situation is over 85 decibels. In that situation, those people are also unable to hear what's happening around. If someone's screaming, if the machine they're driving is broken and is making a lot of sound, of noise, they won't hear it. But they still drive those vehicles. Why? Because there are safety procedures that have been implemented around those jobs to ensure that the people, even if they don't have their ears, they can still use their eyes and other procedures to avoid any incidents. We therefore believe that Mrs. Gagnon could be fit for the job, considering that some procedure could be involved to ensure that no problems arrive with forklift driving. Also, there's a failure to understand the judgment. We also find a judgment where there was a forklift driver there was someone that wanted to be a forklift driver that was also there in the situation of twisting Worthington steel in 2001. There was no judgment that was being concluded on this situation. However, the judge at the end did a prescription where he said that it was favorable to the person that was dead because he said that he believed that the person could have taken the job that was a situation that was very similar to the one that we have presented right now. So even if there was no judgment, the judge itself put his favor in the situation that is similar to the one we have right now. To conclude with all those points, to ensure that Mrs. Gagnon is in a fair situation, we believe that what could be compensating is that Ms. Gagnon could have the job as a forklift driver. And as for compensation with monetary value, we believe $2,000 will be asked, and of this $2,000, $600 will be against for having a judgment against the Quebec Labor Standards Article 139 in the Quebec law, and there will be also $1,400 counseling requests since she had Miss Gagnon high emotional state. I will then leave my colleague David to run out the discussion. Vincent, sorry.
So there's one last point that I would like to bring forward. There's a failure from the part of the company to understand injuries that are caused by forklift drivers. Because we did our research, it was able to find that the Canadian Centre for Occupational Health and Safety named these issues as being the main cause for injury. First, there is excessive speed. Then there is riding with elevated force or load. There is improper warning to others that there is a forklift nearby, and there is improper parking. As we can see from those, and we can conclude, none of those involve Mrs. Gagnon's condition. Therefore, we think that she should be able to drive a forklift, or at least be given the chance to do so.
In order to conclude, I'd like to take us to the beginning, where I said that having a safe environment is exempt of harassment and discrimination. Side Union deeply believes that Mrs. Gagnon will never be able to go back to work in the same way she did. That was her job that she wanted, and she feels ashamed to go back in an environment where she will only be tried for 10 days. We look forward to hearing your judgment, and thank you very much for hearing us.
Thank you, opposing counsel.
There's a preparation period of 5 minutes, and then you will have your 5 minutes. there's only 2 minutes left. Time's over.
Thank you, moderator. Opposing counsel, mesdames and messieurs arbitrators, we began by comparing discrimination to bona fide occupational hazard. As per the definition of the Canadian Human Rights Commission, bona fide occupational hazard is justifiable and not the same as discrimination under two clauses. A, it needs to be made in good faith, and B, it needs to be objectively reasonable. What we stand for today is for the health and safety of the plaintiff, as well as that of all other employees. This decision to not hire her was made in good faith. It is objectively reasonable to not hire an individual with a disability if we cannot accommodate that disability at the moment and put their safety at risk. The definition that this is discrimination is simply not the reality based on the definitions provided under labor laws as a whole. It was brought up that it's not required to be able to hear in order to be safe. While that is the reality across the industry, that simply is not the case at this company. In this company, it's important to be able to hear because there aren't provisions in place accounting for her disability. There aren't even formal provisions in place for the fact that she's on the floor doing her current day-to-day job. All provisions on the fact that other employees know to take care of her and to know that there is an individual on the grounds that cannot hear is on a verbal basis and not on a written one. Until a written basis cannot be put in place, the employer is putting itself at harm and putting its reputation and itself in risk for even larger lawsuits or issues at hand. An employer is accountable for all its employees. By putting one individual behind a forklift without ensuring the safety of that individual and that of other employees, it simply cannot be done by the employer, and this was outlined in the very politely written letter that rejected her from her current position, but let her remain in the position that she was in and has been excelling in for 12 years. The grievance offered to the plaintiff is that they can remain in their current position while working with management and working with the individuals that deemed her unfit for the promotion to build provisions that allow the likes of her and allow individuals with disabilities to be in a role such as a forklift driver. But currently, under the restraints of the 10 days and the time constraints and the limits of budget and provisions that would cause undue hardships on the employer, this simply cannot be done at the moment. It was brought up that we have deemed her unfit for the role. It is not necessarily the plaintiff that we have deemed unfit. However, it is the employer acknowledging that we don't have enough provisions in place to prevent the employee from getting harmed in a role that she may well be very good at. There's a cause and effect idea that was brought into place. The effect is that the promotion was not granted. The cause is not discrimination, it is a lack of provisions in place. It was also brought up that the employer has failed to accommodate this individual. The discussion period for one position took 22 days. It was discussed with head of health and safety as well as the head of workplace security. If these two individuals with collectively 40 years of experience in this company and in this industry believe that this is not a good idea and that the promotion, this is not the right time to do so, ultimately, it's a question of whether or not the plaintiff understands the reasoning and understands that this decision was made, again, in good faith. To accommodate for one individual would mean to put all the other workers at harm. As an employer, we simply do not stand for that. It was brought up that the plaintiff has been driving and biking for years. However, the plaintiff, if they decide to do that, is accountable for themselves. The employer is accountable for the entire company. Furthermore, in order for you to be able to bike and drive while being hearing impaired, certain provisions need to be put in place on your bicycle, on your car, and they need to be regulated by the government. Those provisions are taken upon by the plaintiff. The employer is offering to put provisions in place, but the time simply does not allow for her to be promoted at this time, as opposing counsel is requesting. It was brought up that the injuries, generally speaking, are not the same as those, are not the ones that are being listed here today. However, statistics only show the highest probabilities. They don't show all the realities. We are being proactive and not hiring her and putting provisions in place, rather than being reactive for when an injury does occur. The big point was what can be done. What can be done is that the employee recognizes that currently this is not the right time, but that the employer is working to put a suitable position in place. Thank you.
Esteemed panel, I think the issue at hand is really not comparing apples to apples. We're not able in this discussion to compare what is actually the problem to actual facts. For example, in the Brider versus CN case, it's again an example of not comparing apples to apples. In this case, this sick individual could not wear a hard hat because of religious reason. He would have put himself at risk in the work environment. In this case, Mrs. Gagnon believes that she is fit to do this job, and so it's not a willing of the individual, or it would not cause individual harm. It's really about creating this individual persona that makes it not comparing apples to apples. In terms of the communication, we heard the employer side say that they could not help her in communicating, or they could not communicate with her properly while driving on the forklift, and she could not communicate to others. However, this is another example that the employer has failed to accommodate her and put measures in place to allow her to communicate to other parties. And it was brought up that they've never been able to make those provisions, and that people know about her disability. However, there's never been processes, policies in place, and that's what we're striving for today with this argument. The third point I want to bring up is performance. What we saw the employer side bring up is the fact that her performance has been great as a non-forklift driver. However, they failed to consider the fact that she has a car driving license that has a very good record. This goes to show that they have not been able to compare apple to apple, and in this situation, we are not able to compare things properly, and that she is deemed to work. The fourth argument I want to bring forward is the Article 10.17 of the collective agreement, referring to the fact that if the person is unfit for the job, we can discard seniority. However, something that we may have failed to mention is that this also includes a mutual consent from the employee and the employer to decide if they are actually unfit for the role. So it's really important to consider that Mrs. Gagnon does not believe that she is unfit for the role, therefore this provision would not apply. I want to reiterate something before we leave. It's an example that my colleague brought up earlier. It's the example of a construction worker. On a work site, above 85 decibels, workers are obliged to wear hearing protection. So they will be effectively deaf by artificially deaf. So this goes to show that some people in other industries are able to wear and are able to be actually not hearing what's happening and drive a forklift around or use heavy machinery. Finally, I want to leave by saying that we really believe that there has been a case of harassment, of psychological harassment against Mrs. Gagnon. The promotion was refused to her, and it was not mentioned that she would be reevaluated or we would put policies in place. And that's really where we believe that the employer has failed their duty for care and for providing a very safe environment for every single worker. With this in mind, I would like to thank you for your time, and we'll be looking forward to the decision.
Thank you to both teams. It's over.
Merci, au revoir. Thank you.
Oh,
Le dossier,
je m'en
Non, c'est correct, c'est correct. Non, on va s'en occuper.